Well, good afternoon, everyone. Thank you for joining our annual OOR training. We welcome you here in person and those that are watching through our webinar today. Just a couple notes before we begin the presentation. If you do need a continuing legal education form, in the room, they are available at our registration desk, and for everyone else that's doing it through webinar, they will be emailed to you upon the conclusion of this session, and you'll be able to send that in to obtain your credits. So if you are watching this through our webinar, please make sure you're registered through the site so you can receive that email. Additionally, the PowerPoint presentation that we are showing today will be available on our website for you to be able to download and print on your own, so you might find that useful. And if there's any questions throughout this, as you can see, we do have our open records at pa.gov that you can email questions to that we will be answering during our panel session at the end. The audience in person, you do have index cards that will be collected if you have questions as we go through the presentation. PCN is recording this, so it will be available for you to view later if you so choose. And right now, I'm going to introduce Erik Arneson, the Executive Director of the Office of Open Records.
Thank you very much. Good afternoon, everybody. Thanks for joining us, both here in person and for the first time, we're able to do this via webinar. I want to thank the Public Utility Commission. This is their hearing room. We're using some of their technology to provide the webinar and put this whole event together. So thank you to the PUC for being kind enough to allow us to do that. It's very helpful. Before we get into the real meat of today's presentations, I'm just going to go over a few things. We are always asked about the caseload at the Office of Open Records, and as you can see this year, we're on track to, for the 6th year in a row, have more than 2,000 appeals during the calendar year. We're at 1,919 as of Friday afternoon. We should be over 2,000 probably in relatively early November would be my guess. And that'll be the 6th year that we're in that same general range with a few ups and downs here and there. I'm going to talk about two issues very quickly before we jump ahead into the more legal aspects of today's training. Act 22 of 2017 is now the law of the land. We get a lot of questions about how to access police recordings, and Act 22 is now the mechanism that governs accessing police recordings in Pennsylvania. It applies to any audio recording or video recording that's made by a law enforcement agency, and what that means is that the right to know law does not apply. As you'll see, some of the concepts in the right to know law, such as agency open records officers, were pulled into Act 22, but as a general rule, the right to know law does not apply to police recordings in Pennsylvania. Earlier today, we put a new page up on our website that goes into a little more detail than I'm going to here about how to request these videos. And it applies to law enforcement agencies, audio and video held by law enforcement agencies, and that includes the Office of the Attorney General, district attorney's offices, and anyone else who employs a law enforcement officer in Pennsylvania. So police departments, sheriff's departments would probably be the two most common agencies that you'd think of in that category, and it includes a fairly in-depth definition of law enforcement officer there in Act 22. Requests under this law must be sent within 60 days of the recorded event. That's different than the right to know law, which doesn't really have any temporal limit at all. As long as the agency has the record, you are allowed to request it, and then we go through the process of determining whether it's a public record and so on. With these video and audio recordings for law enforcement agencies, it has to be a request has to be sent within 60 days of the recorded event. It needs to be sent to the agency's arrow. It needs to include the date and the time of the event. You, as a requester, need to identify your relationship to the event. Were you there? Were you an observer? Are you a member of the media interested in covering the event? Whatever your relationship is to the event, that needs to be part of the request. Again, that's very different than the right to know process, where no such explanation is necessary. And finally, if the recording was made inside a residence, the request should identify every person who was present unless that is not known and not reasonably ascertainable. The agencies have 30 days to respond, again, similar to, not identical to, but similar to the right to know law. They may, with a memorandum of understanding, engage either the local district attorney or, depending on the circumstances, the attorney general to provide these responses. And they may deny the request if the recording includes a number of things, including potential evidence in a criminal matter, information pertaining to an investigation, information pertaining to a situation where a criminal charge has been filed, confidential information or victim information, and if reasonable redaction will not safeguard the potential evidence or information that's at issue. The response from the agency, if they grant the request, they can charge reasonable fees for a copy of the recording. Reasonable fees is something that's not defined in Act 22, so I think that we will, over time, sort of see that develop across the state and figure out exactly what that is. Is it different for an audio recording or a video recording? Is it different depending on whether or not redaction is necessary? That sort of thing. And again, similar to the right to know law, if no response is issued within 30 days, you can treat your request as deemed denied, and that is something that can be appealed. And under Act 22, appeals of an agency denial, you have 30 days, 30 calendar days to file those appeals, and they go to the appropriate court of common pleas. They do not come to the Office of Open Records. They go to the Court of Common Pleas. There is a $125 filing fee. Copies of the request and any responses that you received need to be filed along with the petition. Also, proof that the arrow was served with the appeal. And again, that issue, if it was a recording that took place inside a residence, identify everybody who was there unless that is not known and not reasonably ascertainable. There is a provision in Act 22, which makes it clear that nothing in that law precludes either a law enforcement agency or a prosecuting attorney with jurisdiction, particularly the prosecuting attorneys with jurisdiction. Nothing prevents them from choosing to release a video or an audio recording with or without a written request. There is a little bit of a limitation there on law enforcement agencies where in certain circumstances they may need to get written permission from the prosecuting attorney before releasing such a recording. But that's a quick overview of Act 22 and specifically the parts of Act 22. It also did a number of other things, but there's a chapter in there that relates to police recordings, audio and video. So a very quick overview of that. We'll be happy to answer any questions you have on that when we get to the Q&A portion of the program. So if you're on the webinar, feel free to email those in. If you're here in person, feel free to use your index cards, and we'll do our best to get to those. The other thing I wanted to touch on, earlier this year, the Office of Open Records, in January of this year, in fact, the Office of Open Records sent out a survey to agency open records officers, AROs, across the state. We heard back from nearly 1,300 of them. We heard from agencies in all 67 counties, local agencies, state agencies, large agencies, small agencies, any type of agency you can think of was pretty well represented in the responses that we received. We're going to make the full results of that. It's taken us longer than anticipated to get the full results out for a number of reasons I won't bore anybody here with today, but we will have the full results, including the raw data from our survey, available later this month for anybody that wants to really look into it. I'm going to hit some of the highlights here very quickly. I also want to mention that the Legislative Budget and Finance Committee is doing a survey of AROs right now as we speak. I think they're in the process of tabulating data that they have at this point gathered. House Resolution 50 tasked them with that job. And so there will be our survey coming out with the full results in another week or so, followed relatively soon in the coming months with the LBFC study. So for the first time really in the life of the right to know law, we're going to have a lot of good, useful data about its impact on agencies across the state. In our survey, there are more townships than there are any other type of agency in the state, so I don't think it's a surprise that townships would account for the biggest section of respondents. But you can see the breakdown there. Townships, school districts, boroughs, and police departments were among the top 4. We also heard from 30 Commonwealth agencies and plenty of other types of agencies sent in responses as well, including 38 of the 67 counties. And as you can see, 206 of the 500 school districts in Pennsylvania. What I've done for these first 4 questions is I've included the results from, this is the entire universe of respondents, and the responses are the lowest category that we offered and the highest category that we offered, so to speak. So as an example, how many right to know requests did your agency receive in January of 2017? 86.8% of agencies reported that they had fewer than 5 requests over that month, and 3% of agencies reported that they had 20 or more. And of course, everybody else was in between those two. And looking back at the previous year, in 2016, how many did you receive? Nearly 60%, 58% of agencies received fewer than 10 or fewer right-to-know requests in 2016. Less than 1 a month is another way of looking at that. On the other hand, 7% of agencies reported receiving 101 or more right-to-know requests over the previous calendar year, which is getting pretty close to 10 per month. Not quite at the bottom end of that, but there were certainly numerous agencies that did have more than 10 a month in 2016. I see now that I had gone, now let's see here. There we go. My slides are just a little out of order here, so sorry about that. Of the requests received in 2016, how many were from commercial requesters? Over the entire calendar year, about 60% of agencies say they received 5 or fewer requests from commercial agencies, or from, commercial requesters. 4.3% of agencies, on the other hand, had more than 50 commercial requests to deal with in 2016. And how many of your agency's right-to-know responses were appealed to the Office of Open Records in 2016? 93% of agencies were in front of the Office of Open Records either 0 times in 2016 or 1 time. Obviously, that's the vast majority of agencies in the state. And the flip side is that a fraction of a percent, 0.3%, had 21 or more appeals filed with us last year. And then the final question that we asked and that I'll touch on today is, in an average work week, how many hours does your agency spend responding to right-to-know requests? And this one I just broke down all of the answers. So you can see that for most agencies, you're looking at less than an hour a week. The next biggest chunk is 2 to 5 hours a week. And only about 1% of agencies really have a full-time job, sort of a full-time equivalent necessary for responding to right-to-know requests. 2% if you include that 21 to 40 range in there as well. So, as I said, the full results, including all of the raw data that people can look at and manipulate and do crosstabs and whatever they'd like to do with that, should be available sometime next week. And with that, thank you very much, and I will turn it over to George Spiess, our Director of Training, for the next section of the program. Just a quick reminder, again, don't forget to send us your questions if you're watching on the webinar, or to fill out your index cards here in person for that section later. Thank you.
Thank you, Eric. Good afternoon, everyone. We're going to spend the next hour or so talking in depth about the right to know law, primarily from the perspective of an agency and what your obligations are, but also hopefully we'll include some information from the perspective of a requester as well, so that if you're coming at the right to know law from that angle, we'll give you some tips on preparing good requests and what you can expect from agencies, municipalities when you do file those requests. I'll beg your indulgence with my voice. In my advanced years, I'm discovering the world of allergies, and I'm not quite there yet with mastering it. But if I have a coughing fit, that's why. But let's see how we make out. The right to know law as it currently exists became effective January 1st in 2009. Prior to that, Pennsylvania had what was known as the Right to Know Act, which goes back quite a few years. Under that act, if I were a citizen and I was requesting a public record and for whatever reason I was denied access, I, as the citizen, bore the burden of going before a court and making my case as to why that record should be released into the public domain. With the enactment of the current law in 2009, that perspective changed 180 degrees. Now, the presumption is that it is a public record, and that it is the agency, the municipality, the school district, whatever, that bears the burden of showing why the record should not be released into the public domain. And they would have to make that legal case either before an appeals officer or possibly before a judge. So basically, my advice is that when in doubt, you presume that the record is public and it should be released. The other thing that occurred with the enactment of this law is the creation of the Office of Open Records. The Supreme Court has defined us as an independent quasi-judicial tribunal. It's an interesting title. The majority of our work involves writing what are called final determinations, which we'll talk about when we get to the subject of appeals. If an agency is subject to the right to know law, essentially they have certain obligations that they have to meet. The most important of which is to appoint an agency open records officer, whom we like to call an ARO. This is the person that's responsible for receiving right to know requests. It's the person responsible for processing the request and ultimately responding to the request, whether it be a grant, denial, or something in between. Agencies may also come up with their own rules and regulations for administering their right to know program, as long as those rules aren't in conflict with the right to know law. For instance, the right to know law says that agencies may accept anonymous requests. Well, because of that word may, it's interpreted to also mean that they may not entertain anonymous requests. So they could pass a local regulation or practice that basically says we'll only accept those right to know requests where the person has identified themselves, and that the agency is allowed that discretion. And there are several more examples that we could give of which once you got into the law and saw the discretion that agencies are permitted. Agencies can also create their own right to know form, and many do. They like to have their seal at the top, perhaps contact information for their open records officers, and that's fine. However, an agency must also accept the uniform right to know form, which is the one generated out of our office. It's on our website, and many agencies simply will link to that off their web pages. They can do that. Finally, we ask that agencies provide our office, the Office of Open Records, with who your open records officer is. We maintain a database on our website. Oftentimes, we receive questions here as to who is the open records officer for XYZ borough or XYZ school district. So we'll refer them to our website. Unfortunately, it is a voluntary system. You can register right on our website, but it's not always up to date. So if you're here from the agency side, from a municipality, we would ask that you take a look at our website to make sure that your records are up to date. And if not, like I said, you can register the updated information right online, and it'll get moved over to our database, and everything will be hopefully more up to date than it currently is. Agencies are required to post information about the right to know law. Obviously, the law doesn't require that you have bulletin boards, but if you do, or at the very least, you need to have information available to the public about your open records program. Essentially, who is the open records officer and how do you get a hold of them? Emails, phone numbers, mailing addresses, and the like. And then contact information for the applicable appeals office. In most cases, that's going to be the Office of Open Records, our office. There are some exceptions when you're dealing with criminal investigatory records, but for the most part, you want to have information about the Pennsylvania Office of Open Records when it comes to how a person would file an appeal. Then a form for filing a request, you would want that to be available. And then finally, if you have any of those local policies or regulations that are unique to your program, you would want to have those available so that people know what the playing field looks like. I also want to mention that under the right to know law, you're not required to have a website, but if you do, you need to have that information about the right to know law on there. Typically, what we've noticed is that a municipality will have at the bottom of their homepage a link that takes a viewer to another page with more specific right to know program information on there. There are some things that agencies cannot do under the right to know law. The first is that they cannot limit the number of requests that an individual files within any specific time period. There is no numerical limit on how many right to know requests a person can file. Secondly, an agency cannot force a person to disclose why they are filing a right to know request. They can't deny a request based on the reason, or they can't deny a request based on what they think that reason is. But ultimately, the law says that they cannot compel a person to tell them why they are filing a right to know request. So let's talk about requests themselves and what our experience is. What is a good request? And I think that there are three essential elements. The first one is pretty obvious, but it's surprising how often this is overlooked. A right to know request should be addressed to the open records officer. It doesn't necessarily have to have their name. It can simply say open records officer. But if it's not on a form, there are many ways that agencies receive requests for information day in and day out. Depending on the format of that request, it may be considered a right to know request or not. Addressing the request to the open records officer kind of makes it clear that this is a right to know request and should be treated accordingly. So you want to make sure that that's the case. A good request also seeks a record. Now that seems rather obvious, but it's surprising how many times an open records request will not identify a record that the person is asking for, but will simply ask a question. Now, under the right to know law, it's necessary for an agency to be able to identify a body of records that are responsive to the request. So it's possible that a person could ask a question and it would be considered a valid request. But usually that's the exception to the rule, and that a request that is asking a question and is not seeking a specific record, or I should say specifically seeking a record, risks being denied for that very reason, because a record cannot be identified that's responsive to the record. So if you're looking at this from the requester side, you want to be very careful about that. Identify a record whenever possible. Don't simply ask questions, because the agency is not obligated to necessarily answer those questions. If a record is not available, that would help them do so. And then thirdly, and we'll talk about this in more detail, a good request is sufficiently specific. When I do training for agencies, I basically tell them that a person can't come in and simply say they want to see every record within a certain file cabinet. That's not specific enough, and the law was not intended for that sort of situation to occur. Essentially, we get back to that phrase that I used a little earlier here, that a request must be sufficiently specific that a person reading it from the agency side can identify a body of records that are responsive to the request, meaning they can kind of figure out what you're asking for based on how you word the request. So you want to be as specific as possible. You want to use plain language that's easily understandable by a layperson. And hopefully then that will aid whoever is processing your request with identifying those records that's going to get you the information that you're looking for. Now, I think it's helpful if we talked about specifically what a record is, because there are communications that are generated all day long within an agency setting that don't rise to the level of the definition of a record. This is the definition of a record taken right out of the right to know law, and it represents the first cut that an open records officer would make when considering what is responsive to the request. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is created, received, etc., etc. So the key phrase is highlighted: documents a transaction or activity of an agency. Excuse me. Let's talk about what that means. I'll use an example that I've used many times before. If I'm a township supervisor and I'm sitting at home in my family room, I'm on my home computer and I'm on my personal AOL account, and I send a message to one of my colleagues on the board, another supervisor, that basically says, my daughter has a softball game tonight. I'm going to be 20 minutes late for the meeting. We would consider that to be what basically is defined as a transitory message. It's personal in nature. It doesn't reflect my authority as a township supervisor. It has nothing to do with the business before the board, and it has no impact on the public that we serve. Chances are, if a right to know request were received for my emails on a particular subject, that message that I just gave you as an example would not be included because it doesn't rise to the definition of a record per the right to know law. Now let me change up the example a little bit. Let's say I'm that same township supervisor, same family room, same home computer, same personal AOL account, but I send a message to my colleagues on the board. I understand at tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have some concerns about the proposal. Here they are. And, at this point, I'm considering voting against it. But why don't you tell me what you think? Now, number one, I've just violated the Pennsylvania Sunshine Act big time because I'm deliberating outside of the public eye. But for purposes of this example, I think you can see the distinction between the first example and what I just gave you, in that I am exercising my role as a public official. It is business coming up before the board, and ultimately it will have an impact on the public. Clearly, with the second example, if a right to know request were received for my emails on a particular subject area, and that example fell within that subject area, it would be provided as a responsive record. So it's a powerful tool available to the municipalities, and it's the first question that's typically asked. Is it even a record under the right to know law? And we've had a number of cases where certain documents were denied access because they did not rise to the level of a record. Now, the other factor that we talked about with a good request was specificity. This is, I don't want to say an emerging topic, but it's an important one within the world of right to know. And we've had a number of enlightening court decisions recently that have provided some really useful language on this whole topic of specificity. A surprising number of appeals that we deal with, at least a component of them, ask the question, is this request specific enough for a right to know response? So there was a decision last year penned by Judge Brobson where he identified 3 key elements. Not all elements necessarily need to be present all the time, but for purposes of guidance, I think they're very helpful. The first is that the request needs to identify a subject. Whenever we see the term any and all, it raises a red flag because if a subject is not identified, then it begs the question, is this request really specific enough? That file cabinet example that I used is a good one because I'm asking for everything in that file cabinet, but I'm not saying what the records need to be about. Obviously, that would not be specific enough under the right to know law. Then I have to identify a scope, or basically the type of records that I'm seeking. Are they emails? Are they written communications? Are they text messages, phone records, or the like? And perhaps the recipient of those records, meaning, maybe it's myself as a public official. And then third, the request should identify a time frame, meaning a beginning date and an end date. Those dates don't necessarily need to be implicit. They can be implied based on any other circumstances. But it does need to be finite. They can't go off on forever or back into the past without any either direct or implied date specified. So like I said, not all three elements necessarily need to be present all of the time, but I think this is a good starting point when you're considering the issue of is a request sufficiently specific to identify a body of records that are responsive to the request. So an open records officer receives the request. A couple of things need to happen. Immediately, the open records officer needs to make a note of the date that the request was received, because there are hard deadlines built into this law. And once the open records officer, receives the request, the clock starts ticking on one of those deadlines. Initially, when the request is received, the open records officer has 5 business days in which to provide an initial response. So it's helpful to note when the initial response is due, either by noting it on the request itself or some log. The open records officer also wants to maintain a copy of the request until it is fulfilled. We recommend, or it's recommended, that 30 days. And here we say if denied. I'm going to add in here that even if you granted the request, I recommend that you hold on to it for 30 days before disposing of it in any way. Because you may encounter times where you think on the agency side that you're granting the request, but the requester receives the records, goes home, starts looking through them, and they're not satisfied with what you've provided. So they'll turn around and file an appeal without reaching out to you first. So you could have an appeal being processed even though you thought you granted the request. So hang on to everything for 30 days. Reason being is that if after 30 days a person does decide to file an appeal with our office, under almost all circumstances, it's going to be denied or dismissed as untimely. So after 30 days, depending on what your retention schedule is or whatever your practices are, you should be okay. But you don't necessarily need to have the request and the associated materials immediately available if you receive notice of an appeal at that point. And it's our understanding that for Commonwealth agencies with their retention schedule, that they need to hold on to all materials related to open records requests and their responses. I think it's for a 2-year period. Under most circumstances, an agency is only required to provide those records which they have in their possession. They're not required to create a record to respond to a right-to-know request, nor are they required to go outside the agency to obtain a record in order to respond to a right-to-know request, except when we're dealing with what are called third-party records. And this is typically where you have a contractual relationship with a private vendor that's providing some component of a government function. In these particular instances, the agency would receive the right-to-know request, and then they would forward it on to the contractor, who would have actual possession of the record. The contractor would conduct the search and then provide the responsive record to the agency, to the municipality, who would then respond to the requester with that record. The contractor is only responsible for providing those records that are reflective of the contractual relationship that exists between the contractor and the agency. Anything that's outside of that relationship that may have to do with other clients or other work that the contractor does typically would not be provided in response to a right to know request. They would be off the table. But this is the one instance where the agency may have to go out and seek a record that it doesn't actually have in its possession. So the agency has received the request, they've processed it, conducted basically a search for the records, and as I said earlier, they have 5 business days in which to provide an initial response. We want to emphasize that it's 5 of the agency business days. Now, that may seem like a no-brainer, that for most of us who work in a 8 to 5, 5-day-a-week environment, it's 5 business days consecutively. But I'd want to make you aware that there are many municipalities, particularly in the northern tier of the Commonwealth, that are on less than a 5-day schedule. Some of them are only open 1 day a week for business. Per the right to know law in this language, that gives them 5 weeks in which to provide an initial response. So it's 5 of the agency's business days in which to provide that initial response. And that if that response is mailed, then it's based on the postmark date, as long as it falls within that 5 business day window. The right to know law does allow for extensions. That's why we call it the initial response. Because if for some reason an agency is unable to provide the records within the initial 5 business day window, they're allowed to unilaterally invoke a 30 calendar day extension. So you've got the 5 business days and then 30 calendar days tacked onto that if the agency decides to invoke the extension. However, the agency must follow appropriate procedure as defined in Section 902 of the Right to Know law for invoking that extension in order for it to be valid. Number one, which is the most important, is that they need to invoke the extension within the 5-day window. They can't wait until, like, say, the 6th day, suddenly realize that they've missed the deadline, and then say, oh, we're going to take the extension. Unfortunately, they've already done what we call a deemed denial. By meeting the deadline, they've in fact denied the request because they failed to provide the requester with the records within the prescribed deadlines. It has to be done in writing. They simply can't call up the requester and say, hey, we're taking our extension. And an email is fine. If the requester submitted their request by email, then it makes sense that you would notify them of the extension by email. But it must be reduced in writing when you're notifying the requester of such. The agency must provide a reason as to why they are taking the request. And the right to know law affords, it actually lists 7 reasons in Section 902. Many agencies simply come up with a form letter where they check off the appropriate reasons. It could be that we keep our records off-site and it's going to take longer than 5 days to go find those records. Or these records are sensitive and we want our solicitor to review them to make sure we're not giving out anything that legally we're not supposed to give out. And that process is going to take longer than 5 business days. My recommendation is don't just automatically, if you're approaching this from the agency side, don't just automatically invoke the 30 calendar day extension if you don't have to. We receive a lot of concerns and complaints from the citizen side when they assume an agency is doing that the records are readily available, but for whatever reason, the agency automatically takes that 30-day extension. If you can avoid doing that, we realize you're dealing with limited resources, but if you can avoid doing that, we'd recommend it. Then you want to provide the requester with a date when they can expect to receive the response, if you're taking the extension, and an estimate of all costs that the requester could expect to incur. And it is just an estimate. You're not providing a hard quote. It can be a little high, it can be a little low. It gets all settled up when it comes time for the actual exchange of funds with the records. So to reiterate, you've got the 5 business days, and it's 5 of the agency business days. And then if an extension is taken, it's 30 calendar days tacked on to the end of the 5th business day that agencies have in order to provide a response, and the requester can expect to receive the records in question. Let's talk about payment issues, because there's a lot of misunderstanding here and on both sides. So hopefully we can shed a little bit of light on this. An important component of the right to know law is that an agency is only required to provide a record in its current medium. Let me explain what that means. Essentially, it's hard copy versus electronic. So that if a request comes in and it's seeking electronic records, but the agency only has the records in question in hard copy format, the agency can deny that request because they are not required to convert them over to electronic medium as had been requested. And it's true conversely as well. If the request is received for hard copy, let's say printouts of emails for whatever reason, maybe the requester is looking for metadata or something that would be printed out that would not necessarily be received electronically, the agency is not obligated to print out those emails and provide them in hard copy if they don't already have them in hard copy. They can deny the request. Now, at the agency's discretion, they can scan records in and provide them electronically. And they cannot charge for electronic records in most circumstances. Also, at the agency's discretion, they can print out electronic records and provide them hard copy if that's how they've been requested. And they can charge up to 25 cents, 8.5 by 11, single-sided sheet. And I think our fee schedule is 35 cents for color, if that's what's requested. Okay, but it's at the agency's discretion for doing that. There may be limited circumstances where an agency will assess a charge for an electronic record. Typically, that's where it's necessary to redact information, meaning that the agency is going to provide the record. Let's say it's an email, but within that email, there's confidential or personal information of some sort. Let's say a social security number, I think would be a good example. In that particular example, the agency would need to print out the email and then redact by blacking out the social security number and then scanning it back in order to send it electronically to the requester. The agency can charge for that sheet of paper that they had to generate in order to redact. It's just that we strongly recommend that if that's the case, notify the requester up front that they can expect to be assessed charges for the responsive records, because they may not be expecting that. And worst case is that you don't want to surprise people with charges that they're not expecting. So as I said, you cannot charge for electronic records unless you're facing that redaction scenario or some other limited cases that you may encounter. You must allow a requester to use their own equipment if they bring it in to make copies. Typically, this is where the requester has indicated they don't want you to provide copies, but rather they simply want to inspect records, which they're allowed to do. So the agency's in the driver's seat here with, they have to arrange a sufficient date and time for the person to come in during normal business hours to inspect the records. And let's say they're doing that, but while doing so, they pull out a cell phone camera and take a picture. Well, the right to know law allows them to do that. And we have a final determination that validates that. A requester can even bring in copying equipment, a scanner or the like, and use that while reviewing records, as long as it's not disruptive to the agency operations. Like I said, the law allows them to do that. Agencies cannot charge for labor, the actual act of redaction. They can charge for the paper and the toner, the 25 cents a page, but they cannot charge for their time that it takes to redact information. And agencies cannot charge for legal review. They can only charge for actual costs, or what we call pass-through costs. I think a good example would be, let's say there's a request for a blueprint, but the agency doesn't have a large-scale copier, so they have to go off-site to, say a vendor who has a large-scale copier, and they charge $10 a sheet for a blueprint. Well, the agency can then pass that $10 charge on to the requester. Or postage is a good example, where the requester has received or will receive a packet of information. The agency puts it on their postal meter and it's $3.15. That $3.15 can be added to the invoice that's assessed to the requester. So actual or pass-through costs can be charged. Some more payment issues, well, I've already alluded to this. It's no surprises. Best case scenario for all concerned is that the requester is aware or has a reasonable expectation of what charges they're going to incur as a result of responding to the request. Worst case scenario is that you after doing a lot of work and making a lot of copies, you surprise a requester with unexpected charges and they balk at that. And then you're stuck after having done all that work, after having made all those copies, without anything to show for it. So when you receive a request, we recommend you do a quick estimate. And then there's nothing wrong at all with picking up the phone or sending an email back to the requester and saying, we think your request is going to cost, around $30. That way they'll respond back. Either they'll say, oh, I wasn't expecting that. I'm going to withdraw my request. Or, well, no problem. Let's go ahead with it. But that way, you know what to expect when it comes time for the actual exchange of records and funds. I think ideally a mutual exchange is best, but the way that the law is written is that records are provided upon payment. That means that the requester is responsible for paying first, and then they receive the records. If it appears that a response is going to cost more than $100, an agency can demand payment up front before they begin processing the requests. Excuse me for a second. And if you have an arrangement where once the records are ready to be provided to the requester, that you're going to hold them, this is from the agency side obviously, that you're going to hold them so that they can come down and pick them up at a convenient time. Under the law, you're only required to hold on to the records for 60 days. After 60 days, if the requester has not come into the office to pick the records up, you can discard them. You can throw them out. Now, let's say on the 61st day, the requester shows up. Unfortunately, they're out of luck. Those records have been disposed of. And if there was a cost involved with that initial response, the requester is still on the hook for that. They still owe the municipality that fee. And the agency is not obligated to process any further requests until that fee is paid. Furthermore, if the requester still wants the records that were part of the first request, they then have to file a second right-to-know request. And they should expect to pay any fees that are incurred for the second request. So if they haven't picked up the records within 60 days, they could be on the hook for the same records twice if they still want the records. And when I say that the agency is not responsible for processing any further requests, that could be for the same records or really any other records unrelated to the initial requests. But basically, the agency can deny subsequent requests if there are outstanding fees for a previous request. For the agencies, strongly recommend that because of this scenario, have your paperwork in order. Keep track of when requests were received, contact that you had with the requester, any discussions about amounts and so forth. Because if you deny access to a record because there are fees outstanding, the requester can file an appeal. However, if you have your records in order, then that strengthens your case when it comes to the basis of your denial. It's surprising how often this becomes an issue, talking about payment. So you do want to keep track and have good record keeping when it comes to administering your right to know program. So from the agency side, let's say you've received the request, you've taken a look at it, you've considered the records that are in question, and for whatever reason you feel you have reason to deny the request. There is an appropriate way to do that. So let's walk through that. And from the requester side, this is what you should expect if you're being denied access to records. First is that this seems rather obvious. However, the denial letter should describe the records in question. Sometimes that's not always clear. The request may be vague. There may be a misunderstanding between the requester and the agency as to what actually is being requested, so that if it's reduced to writing in the denial letter, that makes it clear for all concerned as to these are the records that are in question. Then, and this is probably the most important part, the agency must provide the legal and factual grounds for the denial. Remember at the beginning of my presentation where I said, now under this law, the agency bears the burden of showing why the record should not be released into the public domain. This is where the agency is meeting that burden, or should be meeting that burden. There is a story here that one of the very first appeals that was reviewed by the office dealt with a right-to-know request that was received, and the response basically was a post-it note that said, "None of your business." Okay? There, the agency clearly did not meet its legal burden in showing why the record should not be released into the public domain. Hopefully I haven't embarrassed anybody here in the audience. This is where the rubber hits the road. And typically what is happening is the agency will be citing one of the 30 exemptions within the right-to-know law that defines a record that allows them to, it gives them the discretion to withhold that record if they feel they have a sufficient business case for doing so. Then the response needs to detail the name, title, signature, the address, and so forth of the open records officer. Because like I said, this is the person who's responsible, who has the authority to deny access to these records. And it's the person that our office contacts if an appeal should be filed. Then the date of the response, that's important because another deadline kicks in, the appeal window. So we need to know when is the agency denying access to these records. And then finally, the agency needs to detail the appeal process that the requester can follow as a result of this denial. As I said earlier, typically those appeals will come to our office, the Office of Open Records. Now, this is an important slide that I want to talk about from both the agency side and the requester side. And it basically is that the right-to-know law is not a confidentiality law. The right-to-know law does not mandate that any record cannot be disclosed. Rather, it gives the agencies the discretion to release records if they feel they have a case for doing so. Initially, let me say this, that if I'm a resident and I come walking into your office and simply ask for a record, nothing is preventing you from simply handing me that record. You do not have to require me to fill out a right-to-know request. There's nothing in the right-to-know law that says you must do that. You can simply hand me the record if there is no other legal impediment for doing so. Furthermore, if I would happen to have a right-to-know request, and let's say I'm asking for a copy of your budget, and you've got a stack of budgets right there on the counter, you could say, you know what, Mr. Spiess, if you withdraw your request, if you tear it up, I'd be happy to hand you a copy of the budget because it'll save me a lot of paperwork and it'll save you some time. Okay, we don't take it personally if you do that. As long as everyone is happy with what's taking place, the person is getting the records they're requesting, and you're not jeopardizing anything by giving that record out, you can do that without any real contact with the right-to-know law. You're allowed to give out records. Unless there is another law that says you're not allowed to give a certain record out. If there is another law that deems a record as confidential or sensitive for whatever reason, that basically trumps the right-to-know law. For instance, law enforcement agencies deal with a law called CREA the Criminal History Records Information Act that defines a number of records as confidential that they can only give out to other law enforcement agencies. If a record is clearly covered by CREA and there's no dispute, then that would trump the right to know law, and that would be the agency's basis for denying the right to know request. Meaning we are denying this request not because of anything necessarily in the right to know law, but because there is a provision within another law, CREA, that says this record should be considered confidential. Many who work in the human resources world are familiar with a law called HIPAA. I think it's the Health Information Privacy and Portability Act or something like that, which basically makes it illegal to disclose personal health information. Well, HIPAA would trump the right to know law. And finally, for school districts, they deal quite frequently with a law called FERPA, the Family Educational Rights and Privacy Act, which basically makes individual educational records confidential. So they could not give out those educational records through the right to know process. They would deny the right to know request based on the appropriate provisions within FERPA, because that law determines that the record is confidential. And there are other laws, again, they're specific to the type of records that we'd be talking about, that may, in fact, determine records are confidential. Whenever that's the case, and it's clearly defined, that law would trump the right to know law, and the agency would not necessarily have the discretion to give the record out, whether they wanted to or not. Also, a record cannot be disclosed if it's protected by privilege. And this is typically where we're talking about attorney-client privilege, where there may be communication between a solicitor and a board, whether it be school board, township supervisors, borough council. That communication, whether it be verbal or written, is considered privileged. And all written communication would be off the table under the right to know law because of that privilege that exists. But again, I'll warn agencies to be careful about breaking privilege, but that's a topic for another training session. Then finally, as long as a law is, or a record is not protected by privilege or considered confidential because of some other law, the agency head does have the discretion to release a record, even though it clearly may be covered by one of the definitions of an exemption within the right to know law. The exemptions are discretionary, not mandatory. So, if you encounter a question, again, feel free to call our office with your question. But if you call and ask, does the right to know law allow me to release such and such? Our answer is going to be yes, unless, and then we'll school you through what I've just talked about. So let's talk about appeals now. Let's say the request has been denied and the requester is not satisfied with the agency response, so they're going to file an appeal. From the date of the denial or when they should have expected the denial, and if an agency fails to respond to a request, like I said earlier, it's called a deemed denial. So from the date that when the requester should have expected the denial, they have 15 business days in which they can file an appeal, typically with our office. There is an exception, but I don't think we have time to get into it today. Now we're talking about the business days of the Office of Open Records, and we follow the state's holiday calendar. So there may be days typically where we are open, but a local government may be closed, like Election Day, or vice versa. But when in doubt, follow the state's holiday calendar. If we are closed for whatever reason and it's not on the calendar, we'll usually send out emails and tweets to that effect. But we've got 15 business days. Okay. An appeal can be filed online on our website. Typically, it takes maybe 20 minutes to complete all the forms and upload the appropriate attachments. But a good appeal that we receive here in our office, and this is the first thing we do, we check to make sure it's complete. And if it's not complete, then we'll order I believe what's called a deficiency order, giving the appellant a limited period of time in which to correct the deficiency. And if they do so, then fine, they've got a good appeal. If not, then we have to dismiss it because it's a deficient appeal. But this is what we look for. First, we want a copy of the original request that was filed by the requester. Then we want a copy of the agency's response if they provided one. If they didn't provide one, you simply mark on the form that your request was deemed denied. Then the requester needs to provide us with a statement as to why they believe the records are public. And then finally, provide us with a statement as to why they disagree with the agency's denial. Okay? If those four elements are there, then we've got what we consider to be, for the most part, at least initially, a good appeal. Once that happens, the appeal gets docketed. And basically what that means, it gets assigned a number. It gets logged into our system here at the Office of Open Records. Typically, it would be AP 2017 - and then a 4-digit code. And then we will issue a letter to all the involved parties, basically acknowledging that our office has received the appeal, and it will include detailed instructions on what should be done. Usually that falls upon the agency, because remember, they have to meet the burden at this point. Now, if you're on the agency side and you receive notification from our office that we have an appeal that involves your agency, if you're the open records officer, we strongly recommend that the first thing you do is contact your solicitor. Everything I've talked about up to this point is pretty much considered an administrative process. Once an appeal gets filed, that independent quasi-judicial tribunal world kicks in, and we're into a legal process. And worst thing that we see is where a case gets kicked before we even have a chance to consider the merits, because it's procedurally deficient in some way. Your solicitor is the person who's responsible for making sure that your response to the appeal follows the correct procedures and is in the appropriate format. My recommendation is don't attempt to do this yourself, okay? As an open records officer, you'll still handle a lot of the logistical legwork, but it's your solicitor's responsibility to provide us with the appropriate arguments in support of your position. So that's probably the best advice I can provide an open records officer here today, is that if you receive notice of an appeal, contact your solicitor immediately. And immediately is immediately, because again, there are hard deadlines built into the appeal phase where you've basically got a 7-day window in which to enter your arguments into the record and so forth. So, you're under the gun, you're under timeframes, because we are under timeframes here as well. And one of those is that we have 30 days in which to issue the final determination. The final determination is basically the product of an appeal. It's the decision. Every final determination that we've ever issued since 2009 is available on our website or available through one of the legal services like Lexis or Westlaw. And on our website, they're in a searchable database. You can go in on any number of fields and see how we've ruled on various issues. Occasionally, we may request a 30-day extension. If that's the case, I'm asking that you grant us that request. We've got a good reason for doing so. And there are, I think our current complement right now is 18, and 14 of those are actually less than that, are appeals officers. And like Erik said at the beginning, it's over 2,100 cases a year that we're ruling on. So there's a lot of work that's coming out of our office. So if you receive a request for an extension, we've got a good reason for doing so. They are legally binding orders, okay? They carry the weight of law. You can take one of our final determinations before a judge and basically say, this is what the Office of Open Records has ruled. In addition to the typical, what I'll define as an adversarial process, we also have mediation available. Our general counsel is responsible for the mediation program, so I'm not going to steal her thunder. She's going to talk about it a little bit here later. But I just want to encourage you to consider, either side, whether you're from the requester side or from the agency side. to consider mediation as an option to the appeal process. We've had some good success stories with this, so it is available for your consideration. Occasionally, people will disagree with our orders, whether it be from the requester side or from the agency side. Once a final determination is issued, there is a 30-day window in which they can file an appeal with the appropriate court. If it involves a local agency, then the appeal would typically be filed with the County Court of Common Pleas. If it's a state agency, then it would go to the Pennsylvania Commonwealth Court. When doing so, you have to notify us that you're filing that appeal. We are not necessarily a party to the appeal because the dispute is really between the agency and the requester, but we have to be notified of your appeal. We may choose to monitor the case. We may choose to file additional paperwork, briefs with it, or in some circumstances, we may actually ask to get involved in the actual litigation. But notify us on either side if you're filing an appeal. So finally, I want to encourage you to avail yourselves to additional resources that are available. I talked about our website. It's more than just our database. We've got a lot of resources there for both requesters, the public, as well as agencies. We've got guides for citizens, guides for law enforcement. We have an agency open records officer guide that's in excess of 70 pages, which you can download for free and refer to whenever you need to. We have email accounts and phone lines that are available just for you to call in with your questions. We realize that if you're doing so, it's probably something that's pretty important to you, and you're working under a deadline. So we'll get back to you with a response as quickly as possible, often in less than 24 hours. We can't provide legal advice to you, but we can steer you towards precedent-making decisions that we've written in the past, where the facts are very similar, to what you're putting before us. Okay, so check out our website. There's a lot of good information on there, and we think you'll. But even if it's not there, feel free to contact us directly, and we're more than happy to help you out. Okay, I'm going to pass the baton now over to our Chief Counsel, Charles Brown, who's going to talk about some recent court decisions.
All right, thank you, George. Good afternoon. I'm going to be talking about some cases that have come out from both the Supreme Court and the Commonwealth Court since the last time we had our annual training. These cases have impacted the scope of the right to know law. They've clarified some procedural issues that we've seen on the right to know law. They've also clarified what is and is not a record. They've also expanded the scope of some exemptions. They've also given us some clarity in terms of what the standards are for bad faith, and also provided some guidance in terms of what it takes to certify a record under the right to know law. So the first case I would like to talk about is a case which came out about a week before our last annual training, and it was really one of the more important cases which have come out regarding the right to know law. So I thought, since we didn't have a chance to talk about it in depth at the last training, I wanted to talk about it more in depth at this training. And that is the Pennsylvania State Education Association versus the Commonwealth, and specifically the Office of Open Records. And this case involved a lawsuit brought by the State Education Association seeking to have a declaration that the home addresses of public school employees was exempt from disclosure. And after about 7 years of litigation going back and forth between the Commonwealth Court and the Supreme Court came down and said that individuals have a right to informational privacy under the Constitution. But that's not without qualification. The court also said that if their right to know request is made for an individual's private information, that you should apply a balancing test to see whether or not the public's interest in disclosure outweighs an individual's interest in privacy. And if the public's interest does, then disclosure is proper, and if it doesn't, disclosure is improper. In the last year, we have had a number of final determinations dealing with this case, and so the case is strictly limited to home addresses, but we've also taken a look at it in terms of other private information. Specifically, we've had individuals, private citizens' names subject to the balancing test and found that they weren't subject to disclosure. One of the other things that we've done in analyzing this case over the past year is looked at the nature of the record to decide whether or not we need to apply the balancing test in an appeal before us. So, for example, if a record contains individuals' names and home addresses, but that record is expressly public, the General Assembly has already applied the balancing test and decided that public disclosure is required. So, for example, tax assessment rolls, they contain individual names, they contain home addresses, but they're also expressly public under the law. And so in that situation, the balancing test isn't necessarily appropriate. It's not required, and we wouldn't apply it. But on the other hand, if a record is not expressly public, for example, under the dog law, you've got dog license applications, have individual names and home addresses. The dog law doesn't make those records expressly public. So in that situation, we would apply the balancing test. And I know that we had some prior final determinations looking at applications for dog licenses where we said they're subject to disclosure, but post PSCA we've had to apply the balancing test, and so the more current final determinations have found that there was no articulated public interest in disclosing those individuals' names and home addresses. So that's this is really a very important case, and I highly advise that it's quite a long read, but it's well worth it, and it's definitely impacted the scope of the right to know law. The next, or actually the only other case coming out of the Supreme Court since the last time we met was Pennsylvania State Police versus Grove, and this was a request for police dash cam videos, and the state police denied it under the criminal investigative exemption, saying that we were responding to an incident, we were doing a criminal investigation, the entire video is off the table. Now, when the case came before the Office of Open Records, the Commonwealth Court, and then later on to the Supreme Court, we all held that just because it was involved with a police incident didn't mean that the entire video was automatically off the table. There may have been some portions of the video which were non-investigatory. So this was a very big case. It really caught a lot of people's attention over the past year. And the reason why I wanted to bring this to your attention is because this is the case which directly led to the passage of Act 22. And as Erik mentioned, Act 22 has now taken law enforcement video and audio out of the right to know law, away from the Office of Open Records, so that if you can still request those records, but if you're denied, you can't appeal the Office of Open Records. There are some very technical requirements with regard to appealing to a court of common pleas. Erik mentioned that our website does have that information. I highly advise that you go to the website. It's a great resource, but also nothing substitutes for taking a look at the statute. So Grove was a very important case, but there's still instances where you can get access to police videos. You just have to go through a different route. The next case that came out the Commonwealth Court involved Porngate. This was a request for the investigative report into the investigation of the use of the Attorney General's email servers. And at the time of the request, the report wasn't finalized, and eventually there was an appeal to the Attorney General. It eventually went up to Commonwealth Court. And during the pendency of the appeal before the Commonwealth Court, a redacted version of the report was made available, but it also included a number of appendices, which were a part of the report, which was requested, but they were redacted. And the reporter, Wallace McKelvey from Penn Live, wanted the court to take a look at those appendices to see if the redactions were proper. But the court said no, and this goes back to a point that George made, and the court looked at the records and said, at the time you made the request, these appendices didn't exist. And so you're only entitled to records which exist at the time of the request, so we're not going to take a look at these records. That doesn't mean that you can't file a new request for the records, but this case reiterates the rule that if the record does not exist at the time of the request, it's not responsive to the request, and you're not required to give it. I mean, you can always exercise your discretion, but technically speaking, it's not responsive to the request. No, not that one. Let's see. The Allegheny Port Authority versus Town. This case dealt with whether records which were created prior to an investigation are subject to the investigative exemption. And what we had here was we had a municipal bus was involved in an accident. There was video of the accident, and the requester who was involved in the accident wanted a copy of the video. The authority denied access, saying it was related to a non-criminal investigation. And when it came to appeal to us, we said, well, wait a minute, this video was created prior to your investigation, and it exists independently of your investigation, so we granted access. When it went up to the Commonwealth Court disagreed, and they looked at some of the evidence that the authorities submitted before them, and they found that the video, which was on a video loop, was never downloaded except when there was an accident and the authority was investigating property damage claims. And they testified that they had absolutely no other use for the video. And the court found this very persuasive. And the court also looked to the Grove case, which held that videos which have a purpose other than an investigation may be subject to disclosure, but they saw these videos had no purpose other than to assist in an investigation, so therefore they were exempt from disclosure. So if you're looking to see whether or not a record is subject to the investigative exemption, I would look to the purpose of the record to see whether or not it's investigatory. If it is, it's going to be subject to the exemption. If it isn't, it's probably not. I think I've got George's problem. What's it? Yeah, if you have some. The next case is the first of three cases we have involving the Philadelphia District Attorney's Office. And the issue here is what is required to certify a record for purposes of the right to know law. Now, Section 904 obligates agencies to certify records if requested by a requester. And here we had a requester seeking a certified copy of a police dispatch report. And the agency open records officer issued a certification saying that this is a true and correct copy of the document which is in our possession. The trial court said that that was good enough. And when it went up to the Commonwealth Court said, no, that's not good enough. For purposes of Section 904, you're not merely certifying that the record is a true and correct copy of what's in your possession. You also need to be able to certify it such that it's admissible in evidence in litigation. And so what that means is it has to meet the requirements of Rule of Evidence 9024, as well as Section 6103 of the Judicial Code. And basically what that means is it requires that not the open records officer, but the official custodian of records certify that it's as to its authenticity. And there's a number of other requirements based on the type of the document, but that's a little bit beyond what this training's for. So this case, gives you some guidance if you're an open records officer or if you're a requester and you're looking for, a document to introduce into evidence, what is required under the right to know law. You need to follow legal requirements to get it into evidence. This next case is pretty interesting, and I highly, advise everybody to read it. There's a lot into it. You really got to dig down into it. But it really clarifies what the procedure is for enforcing a final determination. And there's a distinction between what is whether the appeal has been filed with the final determination or whether no appeal has been filed. And what happened here was a requester was granted access to records. He filed a petition to enforce in the local court. It eventually made its way up to the Commonwealth Court, and the Commonwealth Court said a petition is not the proper vehicle to enforce a final determination where no appeal has been filed. And the reason being is the court looked at that scenario as an enforcement action being an original action. And under the rules of civil procedure, original actions can only be filed by a summons or a complaint. So the court said that the correct vehicle where no appeal has been filed is to file an action in mandamus. But on the other hand, the court also noted that where an appeal has been filed, that's not an original action, and that the court that heard the appeal still has jurisdiction over the appeal, and so the proper vehicle would be to file a petition. So the takeaway from this is if you're looking to enforce, a final determination, if no appeal has been filed, an action in mandamus. If an appeal has been filed and you prevailed and you still don't have the records, you can bring a petition to enforce. So that's, but again, I highly advise you to read that case because there's a lot going on in it. This next case considers the issue of what is a record of an agency. And what we had here was an insurance company. Actually, a requester asked for the payment rates that an insurance company paid to its service providers. And this information was in the possession of the insurance department. There was no legal requirement that they have this information, and they had no use for this information, but they still had it, and the requester wanted it. And eventually, the case went up to the Commonwealth Court, and the Commonwealth Court analyzed the issue of, what is a record? And as George pointed out in his presentation, a record is information which documents a transaction or activity of an agency and which is received or retained pursuant to law or in connection with an agency activity. And here the court found that there was no reason for this information to be provided. There was no legal obligation. Therefore, it wasn't received pursuant to law, and the agency had no use for it. They just possessed it. And so it wasn't used in connection with an agency transaction or activity. So just because an agency has information which may be somewhat related to its functions doesn't mean that it's going to be a record for purposes of the right to know law. And if it's not a record, it's not accessible. Here's our second DA case, and this involves a gentleman by the name of Ryan Bagwell. And this case reminds us that agencies can and will be penalized for bad faith if they act in bad faith. Mr. Bagwell was in litigation with the DA's office in a very contentious litigation, and he was subject to a discovery order, which limited what he could receive and when he could receive it. Well, he decided to avail himself of his rights and filed 2 right-to-know law requests. And the DA said, no, you can't do that. You're in litigation. You're subject to a discovery order, so you're not getting the records. He appealed to us. We said, no, you're entitled to the records because your status as a litigant doesn't preclude you from receiving records under the right-to-know law. And there's actually some case law on that. The Philadelphia trial court agreed with us, but more importantly, slapped the DA with a $500 fine for basically bad faith, misstating the state of the law. The DA appealed to the Commonwealth Court, and the Commonwealth Court, with some rather strong language, upheld the trial court and said that the DA violated at least 3 sections of the right to know law and also misrepresented the state of the law with regard to litigants' rights under the right to know law, and they upheld the civil fines. So this case does remind us that that the courts can and will impose bad faith penalties if an agency does act in bad faith. The next one I just want to touch upon briefly. This is also talks about bad faith. This was an enforcement action between a newspaper and the Department of Corrections regarding records related to inmate illnesses out at SCI Fayette. There was a lot of press coverage regarding this. During the course of this enforcement action, the newspaper asked for bad faith sanctions. The procedural posture of the case didn't warrant the court to impose bad faith sanctions, but they strongly hinted that there might be bad faith in the future. And what they said, some of the things they said they would look to is whether there was a good faith search for the records. They pointedly noted the fact that the DOC's representative said that he didn't even look for the records until long after the final determination had been issued. Another issue that they would look at is the timeliness of compliance with our final determination. Our final determinations give agencies 30 days to turn over the records. And here the court found that DOC, didn't meet the 30 days, but they only missed it by a couple of days, and so they were willing to cut them some slack. But they strongly hinted that if you don't comply with our final determinations within the appropriate time period, that they might find bad faith. And then the final issue that they looked at was whether all responsive records were provided, and if they weren't provided, why. So this case does show that the courts are taking bad faith very seriously. Mount Lebanon versus Gillen involves a discussion about the parameters of the donor exemption under the right to know law, which exempts from disclosure the names of individuals who make donations to the government. And the case involved a deer culling program out in Mount Lebanon, and the requester wanted the names of the volunteers who were willing to hunt the deer, as well as the property owners who were willing to allow deer hunting to occur on their property. The agency denied the request, saying that these people are donors, and therefore under 708B13, it's not subject to disclosure. When it came to us, we said that no, the donor exemption is limited to individuals who make financial contributions, monetary contributions. And since these individuals haven't made monetary contributions, the exemption doesn't apply. When it went up to Allegheny County and subsequently to the Commonwealth Court, those courts both disagreed, and they said that the word donation is not limited to a monetary donation, but it also includes the donation of services, the archers, as well as the landowners for the temporary use of their land. So, the court here, sort of expanded the scope of the exemption. This was a case of first impression, so going forward, if you've got a donor who's given in-kind contribution, not money, they could be qualified for the donor exemption. And one thing to point out, the donor exemption is limited to individuals. We do have final determinations which say that a corporation can't avail themselves of this exemption. This was a case that I actually handled, and I told Erik that I think my brain hurt for a week after dealing with this case. It was kind of complicated. But the issue really was, what was the public nature of a record on the basis of a statute other than the right to know law? And here there was a request for all unsuccessful bids for contractors who were looking to participate in the Commonwealth's and PennDOT's bridge repair project. There's currently a project to maintain and repair all bridges in all structurally deficient bridges in the Commonwealth. PennDOT denied the request, saying that they weren't public under the Public-Private Transportation Partnership Law, also known as P3. And specifically, they said that only successful bidder information is public, and therefore unsuccessful bidder information is not accessible. When it came to us, we looked at it, and we said that, well, the P3 law is silent as to unsuccessful bidders. It only talks about successful bidders, and therefore, we look to the right to know law, and basically all bid information, with some limitations, is subject to disclosure under the right to know law. Basically, we said, had the General Assembly intended to make unsuccessful bidder information confidential, they would have expressly said so, but they didn't say that. When it went to the Commonwealth Court looked at the P3 law and the right to know law, and they came to a different conclusion. And they looked at the P3 law, and they said that, well, this law was really intended to pull these projects out of the procurement code, and since the procurement code is subject to the right to know law, this evidences an intent on the part of the General Assembly to exempt these types of records from the right to know law and make them accessible only through the P3 law. And had the General Assembly intended to make unsuccessful bidder information public, they would have said so. There's a old saying in the legal business that for every rule of statutory construction, there's an equal and opposite rule of statutory construction. So, but those guys wear the black robes. But here's a situation where you've got the accessibility of a record being governed by a statute other than the right to know law. Game Commission versus Fennel talks about the evidentiary burden in appeals before the right to know law. And this case involved an investigation into a complaint about a neighbor's tree stand. The Game Commission came out and did their thing. They produced a report. The requester wanted to copy that report because it was their tree stand, and they wanted to know if they had to tear it down. And the Game Commission said, this is a report of a non-criminal investigation, so it's exempt from disclosure. When it came to appeal to us, the Game Commission said the same thing, but they didn't submit any affidavits. And so we looked at it, we said, well, we've got no evidence, no affidavits, and we granted access. When it went up to the Commonwealth Court said, you don't need any evidence. There's no dispute as to the nature of this record. The requester has acknowledged that an investigation took place, so Game Commission, there's no need for you to provide any evidence. As a lawyer doing the right to know work, one of the interesting things about this case is that they didn't talk about the Game Commission's authority to conduct any investigation. And under the Chihuahua case, there needs to be some sort of legislative grant of fact-finding authority for an investigation to fall within the investigative exemption. Simply put, not all investigations are subject to the investigative exemption, but this really wasn't talked about, and I thought that was kind of interesting. But in any event, if there's, for practitioners, if there's no factual dispute with respect to the nature of the record, evidence isn't required. But having said that, I would counsel you that evidence is always better. This next case is one that we actually filed an amicus brief in, and it concerns itself with the court orders. And there was a request made to the Philadelphia DA for court orders regarding the requester's sentencing and incarceration. And the DA said, you can't have these are judicial records. Judicial records aren't accessible under the right to know law. When the appeal came to us, we said, well, these records are in the possession of the DA, and looking at the case law, these aren't the type of records which the courts have said are not subject to disclosure. For example, they're not court personnel records. They're not records of phone calls that the judges make. These are court orders. When it went up to the Commonwealth Court disagreed, and they said that anything related or anything created by the judiciary is a judicial record. Now, they limited their holding in this case to just court orders, but the language is pretty broad. They said anything created by the judiciary is a judicial record. But they did acknowledge that there does exist a common law right to court records. So if you want a court order, you can't go to an executive branch agency. You've got to go to the issuing court. Now, in terms of practice before us, if we see an appeal involving a court order, it's getting denied immediately. We're not going to waste anybody's time. It's just, the court has been very clear that court orders, aren't subject to disclosure under the right to know law. Now, currently, this case is unpublished, but the DA has filed an application to publish it, which is going to give it more precedential value as a case. I fully expect the court to grant that application. Now, the last case I want to talk about deals with, George talked about fees, and this also talks about fees. It involves an unpaid fee of $6.32. Now, Section 901 requires that all fees be paid to get access to records, and as George pointed out, the Commonwealth Court has routinely held that if you don't pay for prior requests, an agency can deny your current request. Well, Mr. Brown filed a request for records. DOC denied it, saying you owe us money. When he appealed to us, DOC gave us an affidavit saying that, we got a request, we granted the request, it cost $6.32. He didn't pay. On the basis of that, we denied it. When it went up to the court said that affidavit isn't good enough. Said that, we don't know, what records were provided. We don't know how many records were provided. I think implicit in the court's decision, they wanted to know what the postage was because clearly there was postage with with a 32-cent figure. So if you're going to be participating before the Office of Open Records as an agency and you're going to be denying on prior unpaid fees, your affidavit needs to give a little bit more detail other than saying he owes us money. Tell us what you gave him, tell us how many pages it cost, tell us what the postage was. Give us as much detail as possible. So those are the most important cases that I could see from the last year. And if you have any questions during the question and answer panel, we'll be happy to answer them.
I want to interrupt real quick. Speaking of questions, if you've written any questions down, please pass them over to the door side, and Faith will collect them, and we'll take a look. Thank you.
Thanks, George. I had that on my list. All right, so I'm the general counsel. My name's Delene. I just have 2 slides to go through before we open up for our question and answer panel. First, George did briefly touch upon this, is our mediation program. This year, we've doubled the number of mediations that the office has conducted compared to the previous year. The mediation process, I believe, has been very successful. It's a nice alternative. The benefits are that it is less litigation and appeal cost for the parties involved. No appeal rights attached to a concluded mediation. And also the upside, once again, is if a mediation is unsuccessful, the parties can, one party can decide they don't want to go forward with the mediation. It's then assigned to appeals officer, and it goes through the typical appeal final determination process. So a final determination would be issued in 30 days. So you can look, there's more information. I have the link, it's on our website, and we're always happy, as George said, to answer any questions. Oh, wait. I went backwards. No, I have one more. There we go. Okay, and the last topic is regulations. We are in the process of promulgating regulations. We also have a tab on our website that you can look at the draft regulations right now. There will be, we're going to do proposed rulemaking. There will be plenty of opportunities for public comment on our regs as we go through this process. There's the link on the slide. You can take a look at it. It also outlines the exact process that the agency will take, the steps we will follow to promulgate our regs. So it's a really exciting step for the office. We have guidelines in place right now, but we're hoping to get the regs, through the next year. Thank you.
Very good. All right, we are running a little bit ahead of time, so we're going to have plenty of opportunity for questions and answers. So just another reminder, if you're watching this via the webinar, please email us any questions you have. The email address is on your screen. It is openrecords@pa.gov. And if you're here with us in the hearing room, please go ahead and write down your questions on the index cards you were provided and pass them toward the door side. And we will hopefully be able to get to everybody's questions, or just about everybody's questions today. First, I wanted to just follow up with one of the cases that Charles had talked about, the Philadelphia District Attorney's Office versus Stover, and it dealt with court orders. And Charles, you had mentioned that if we get an appeal involving court orders, that we would deny it. But on the front end, is there any actual prohibition against an agency if they happen to have that court order in their possession? Is there any prohibition against them choosing to release it using their discretionary authority?
Absolutely not. And I think the point to keep in mind is that court orders in and of themselves are subject to a public right of access under the common law. So there would be nothing to prevent an agency from exercising their discretion to release that record.
Very good. And now with the Q&A, what we'll do, I'll ask the questions. I may chime in from time to time, but then Delene and Charles and George, any of you feel free to chime in on any of these questions. First one, what is considered sufficiently specific when the request involves emails? If we could give a few more specific guidelines related
take that
to
one.
email into that.
Alex. Sorry. There's really no difference with emails. It's, an email would or would not be considered a record, and you would apply the same standards to an email, even though it's an electronic medium.
George, if I could just chime in real quickly. The case that George referenced, it involved emails of former Secretary of Education Dumaresque, and it asked for all of her emails for almost a year period. And the court said that the time frame was too long, and the lack of subject matter basically made it a fishing expedition. And I think the point to keep in mind about specificity is if you're going to be submitting a discovery type request, it has a high likelihood of being insufficiently specific, because discovery tends to be completely wide open, and the right to know law is not intended to be is not a discovery. It can be used as a discovery, but the standards are different. It needs to be much more specific in terms of the scope of the request, the time frame, as well as the subject matter. If somebody asks for an email for a specific date but doesn't attach a subject matter, we might find that specific, even though there's no subject matter, given the extremely narrow time frame. So it's a very fluid concept.
And individuals too, right, Charles? Like we have the time frame, we have the subject matter, and then individuals to and from, typically too, is what I think
Sure.
they're going to look for. So as long as that's covered, the email should fall under that.
That's,
Repeat that if you would, Charles, just for...
the question was, what if it's a request for all emails on a server? Let's say there are only 3 email addresses on the server. That might be one situation versus if you're asking for the Commonwealth server and you've got 80,000 addresses.
Then you might want to do it by individuals. If they would say, hey, it's between this person, or this office, maybe you could narrow it down.
Very good. Here's a question from somebody on the webinar. Let's say a request that comes in on the 1st of the month, happens to be a Monday, and the arrow doesn't notice until 8 days later that the request landed in his junk folder instead of the regular inbox. So 5 business days have already passed, but how does the clock counting work in a situation where the email program misfiled it as spam and it was later discovered?
Check in your folders. Check all.
That would be the Donahue case.
Right.
It's when the open records officer received it. In that case, an email request went to an administrative member of the governor's staff, who's not the open records officer, and it took her, probably about between half a week and a week, to forward it to the open records officer. And there was a lot of litigation, it went all the way up to the Supreme Court. And they basically said that the clock starts running once the open records officer receives it.
And that, I'm going to sort of piggyback on that, George.
Let me interject too, Erik, on that last question. Just,
sure. Let me run through this. Is right on point as well, and it ties in. What is the mechanism when an appeal has been filed to the Office of Open Records, but the original request had been mishandled by the agency? In fact, it was never forwarded to the arrow. What should the agency do in front of the Office of Open Records at that point? So 2 very similar.
Right. I'm just... On the question when it comes into the open records officer, there have been cases where, an open records officer goes on vacation. You commonly see that. So you have to make sure that someone else is checking that inbox, that individual's on vacation. And I've seen requests that have come in through a fax machine, and no one ever checks the fax machine, as well. So those are just some practice tips that you want to be cautious of. Charles, do you want to talk about?
Yeah, I think if there was an appeal filed with us and the request never made it to the open records officer, we would dismiss it as premature because the clock, technically didn't start running until the open records officer received it. So if that makes sense to everybody.
I'll weigh in here a little bit too, because I have a lot of discussions with agency open records officers around the Commonwealth. And some of these municipalities, they may be small townships up in the northern tier area where, like our survey shows, they may only get 1 right to know request a year. we don't expect them to be on the top of their game with the right to know law with that level of activity. And mistakes are made. But I think the bottom line is if the agency is acting in good faith, and showing that they want to comply, they want to do the best job they can, typically they can expect a little bit of leeway there. It's when there is intent to delay and confuse and basically subvert the intent of the law that people get themselves into trouble. Typically, requesters are very understanding. There's a lot of people who will point to the right to know law and say, it's created all these problems. My position is that the right to know law is not the problem, but rather it's rooted in the relationship between that requester and the municipality in some way. And the right to know law is simply a tool being used by both parties to confuse each other and make each other angry. But I think the bottom line is that if the municipality is acting in good faith, then they can expect to be treated well.
Very good. And it's sort of a pattern of questions here. This one's got just enough of a fact difference that I'll ask you to address it as well. What happens if an arrow has blacklisted an individual because of rude and spam-like emails, and then that individual decides to submit a right to know request through that blacklisted email address?
Blacklisted, huh? That sounds like...
It wasn't me.
I was going to say, I think you still, have the responsibility to check if it comes through that account to see if a request has been made. I mean, that would be
And I think I agree, and I think as Charles said too, if it's something that the requester, if the agency just never sees it in that circumstance, and then the requester appeals to the Office of Open Records, the agency can try and assert that they have never seen the request before to reset the clock, or depending what the request is, it may be something that's just as easy to sort of sort out through an appeal process.
Although I will mention that there have been a couple of cases. I know of at least one where somebody was blocked on Facebook, and there was a significant scolding by the federal district court down in Virginia. They not allowed to block people. It's a violation of their civil rights.
It is something to be very, very careful of. Another question here relates to using forms to submit right to know requests versus just sending them in through standard email. And basically the question is, why does the right to know law allow people to send in requests off of the forms, and is there anything that can be done about that? And I think, if I'm not mistaken, that if the agency puts together a policy and officially adopts that policy, they can actually require all requests to be on a form. Now, every agency has to accept the standard right to know form, request form that's promulgated by the Office of Open Records, which we hope to have some updates on over the next month or two. But agencies can also promulgate their own forms and then require the use of one of those two forms if they adopt a policy stating that. And then that policy obviously needs to be easily accessible for anybody submitting a request.
So if a requester, is going to make a request, they should check out the local rules, the rules of procedures, that agency has before making a request. You can make sure you comply. If they do require that you submit it on a form, make sure you submit it on the form. I think agencies just do it to make it easier for them to, when they get a request in, to understand what you want, what the requester is asking.
Another question, and just another reminder, we still have plenty of time for questions, so feel free to send them over toward the door if you're here in person, or email them to us online at openrecords@pa.gov. Will the Office of Open Records, if the case is similar but not the same, issue a final determination contrary to a Commonwealth Court decision?
No.
No.
No, that would be no.
That was easy. I like that.
Easy questions are always appreciated. Would a third-party township code enforcement officer, so that sounds to me like somebody who's not an employee of the township but is a contractor, perhaps, a third-party township code enforcement officer, would they be considered a law enforcement officer? That might be trying to tie into Act 22.
Right.
I think you need to look at the statutory definition of the code officer. Do they have law enforcement authority? I mean, do they have, the right to arrest individuals? I don't know enough about code enforcement officers. Game wardens, they have law enforcement authority. Dog law wardens, they have law enforcement authority. I think there are some members of the Department of Labor and Industry who have law enforcement authority, but it's granted by statute, so you need to look at the statute.
Very good. Since open records officers enforce the right to know law within their agencies and school districts and all operate under the executive branch of government, should all school districts now follow Act 22 instead of the right to know law? I think that perhaps since I'm the one that talked about that most, may have caused some confusion. Act 22 only applies to audio and video recordings, and only to audio and video recordings of a law enforcement agency. I don't believe that school districts are law enforcement agencies. It's not executive branch agencies, it's law enforcement agencies, and it's only for audio and video recordings. If you want some other kind of record from the police department, for example, a budget document, that still goes through the traditional, normal right-to-know process that's been in place for the last 8-9 years.
I think we have a follow-up.
Yes.
That's what I was.
If the
I think that is probably something that wasn't thought through with Act 22. I think they were probably looking at traditional law enforcement. But as I was listening to the question, that's exactly what I was thinking. So I think there could be an argument that that in that circumstance it would be a law enforcement video. But
wasn't there the Central Dolphin? Was there a case with the recording on the school bus? Did that ever?
It was pre-Act 22.
That was.
That also wasn't. It was law enforcement.
Right. Right.
The definition of law enforcement officer in Act 22 includes those who are empowered to make arrests for offenses enumerated in this chapter or to conduct investigations of offenses enumerated in this chapter. So if the SRO falls under that, I think a case could certainly be made that those videos that you're referencing might fall under Act 22. It's probably something that will have to be examined a little bit on a case-by-case basis, at least initially, until either a court or us or both weigh in on that. All right. I would like to know when the law will be updated to reflect all of the changes that have been made by decisions from appeals. And I'll just touch on that a little bit. Probably, as the question is written, never. Because once case law is established, there's not really a pressing need to have it reflected in the statute as well. However, there are any number of bills pending in the General Assembly right now which would make changes to the right to know law. I think the most comprehensive of them, it's fair to say, is Senate Bill 465. So to the extent that you are interested in the right to know law and looking at changes that could be coming down the pike during the 17-18 legislative session, I'd encourage you to look at Senate Bill 465. It might be 456. It's Senator John Blake is the prime sponsor of it, and it contains a number of issues in there. I think it covers pretty well the universe of issues, although not all of the other bills that are introduced would address all of the issues in the same way, but it's a good, certainly a good starting point. Some more questions. Here's one from somebody here in the room. When redacting certified payrolls, does there have to be a way to identify the employee?
No, I think employee names are exempt from certified payrolls.
And ID numbers too, like employee ID numbers as well. Yeah. Yes.
And what is a certified payroll?
It's usually a document which establishes what the wages were paid for purposes of the prevailing wage law.
Right. So that is not, for example, typically, it's not agency employees, state agency employee salaries are.
Typically a union.
Right, right. And state agency employees are available on PennWatch. Local agency employee salary information is available under the right to know law as well. Is it possible to receive a copy of the PowerPoint presentation from today? Yes, it is. We will be posting it online on our website after the session ends. Is video from traffic cameras installed at intersections available under the right to know law?
Yes, I think if it's a government record, yes. Although we have had some situations where the traffic cam was used to investigate.
It documented a criminal activity if they wanted like an accident.
Auto crashes.
An accident. Yes.
We've actually never reached the merits on it, but if a record's in the possession of a government agency, it's presumed to be public, and video certainly falls within that rubric.
And I'll just add the caveat that the vehicle code sometimes has some interesting twists and turns in it, so we'd have to take a close look. But in respect to calendar days, since many government offices are closed for extended holidays, does a calendar day, for example, the 30 calendar day extension that agencies are permitted to take under certain circumstances, does a calendar day also count those days that the offices are closed?
No.
I think it does for calendar days, right? Not for business.
If our office is closed for an appeal?
Yeah, I mean, I think the caveat is the calendar days, let's say the holiday, you extend the 30 days and the holiday falls within the middle of those 30 days. You count those, those holidays for purposes of the 30 days. But let's say that holiday falls at the end of the 30 days. We follow the standard statutory rule that if a deadline falls on a holiday, you go to the next to the next day.
Very good. If a private company requests information requesting all contractors, payment information, check dates, etc., if those records are kept on a special software program, is the agency required to convert records to another program such as Word or Excel in order to comply with the request?
It depends. Typically, you could argue that you're not required to create a record in order to respond to a right to know request. And in most cases, that will hold. However, it's almost case specific sometimes, where if an agency has the ability to simply push a button that converts the output of specific software to a certain format within that medium, then they have to do it. Like maybe multiple versions of Word, or we get questions about QuickBooks an awful lot, where QuickBooks already has pre-formatted reports that can be generated simply by pushing a button. It's not a matter of someone sitting down and having to physically arrange the data themselves. I think in those particular instances, the agency would probably be obligated to provide the data. It's, like I said, though, it's when, for instance, when the private company provides a template that they want the agency to input by cell various data so that the private company can then turn around, merge it with their database, and typically what happens is they then sell that information in the aggregate, then the agency would not be obligated to go through that exercise.
Yeah, and I think the distinction which George is making is that information in a database has to be made available, as opposed to other types of records where the right to know law says that you have to provide the record in the medium requested. If you don't have it in that medium, then you have to provide it in the medium in which it exists. But I think there's a distinction between that and a database. If it's in a database, you've got to be able to provide it in whatever medium it exists.
Very good. Student disciplinary records, are they exempt under the right to know law, even in a bullying case where the victim's family would like to request the information?
Those records would fall under, could conceivably fall under the Federal Educational Privacy Act, FERPA. If it's contained within a student's educational file, I do believe that we have some final determinations, which we have found that disciplinary records are the type of records which would be contained in an educational file, and so they're subject to FERPA. Right. If it isn't contained in an educational file and it's not subject to FERPA, it would be subject to one of the exemptions under the right to know law, and it's probably going to be fact specific, but at minimum, you'd be redacting the student's name.
A little bit related to this is we oftentimes run up against requesters who are seeking information, for instance, about themselves that may be of a sensitive nature, and they're frustrated that they can't obtain those records through the right to know law. And what I found is it's helpful to explain to people that under the right to know law, when you're requesting a record, basically you're saying it's public and you want everyone to see it. And is that really the case? Because usually it's not. And oftentimes in that particular scenario, there's another mechanism for obtaining those records. We don't always know what that mechanism is. We try and steer people in the right direction. But oftentimes, while it may be justified that the person get a chance to see those records, the right to know law is not the appropriate mechanism for that to happen.
If I could just make 2 points on what George said. With respect to the original question with regard to the parent who wants to see it, the identity of the requester is irrelevant under the right to know law, so that's one point. The other point is that FERPA itself does provide a mechanism for accessing records which are protected by FERPA. It's under federal law, and if you don't get the records, you've got to go to district court, but you can't go through the Office of Open Records. There's a separate mechanism under FERPA.
Right. And we also see a lot of inmate requests for health records, which under the right to know law aren't accessible, but the Department of Corrections has an actual process for them to get that information in other ways.
And that ties in just a little bit to this. Is there ever a time when the ARO should consider who the requester is when making a decision to grant or deny a request?
Yeah, again, the identity of a requester is not relevant, but here's a caveat to that. I mean, we saw a situation where a request was made to an agency for certain records, including addresses, and the individual making the request was an inmate who was convicted of arson and witness intimidation. While you can't say that, who you are is a basis for denying the request, you can certainly raise, one of the security exemptions and say that if we disclose this record, there's, a reasonable likelihood of physical harm, to somebody. So, but, technically the identity is not relevant, but there may be other avenues for dealing with that.
Please discuss when an agency should provide notice to a third party regarding the potential disclosure of a record. And I think I'll ask us to talk about two situations. One is when the third party is just sort of an individual whose information might be part of that record. And the second is when it's a third party contractor who maybe has submitted the records to the agency in the first place.
Right. Third party notice is a really hot topic, in front of the courts right now. So the regulations are going to attempt to help provide guidelines on that topic. But we do request that third parties are notified by the agency if their information, personal information, I can speak of. Charles, you can talk about the contractor cases, are notified that their information is subject to right to know law requests and allow them to intervene, to provide notice at that first level. And then also, if there's an appeal on the information, we also allow direct interest participants to participate in appeals where it involves third-party personal information.
On the contractor aspect of it, I think there are a couple of things to consider. Number one, If a contractor is in possession of public records, you have to go to the agency, and the agency goes to the contractor, and then the records have to deal with a governmental function, and they have to be directly related to that governmental function. If you're asking for who's employed by the private contractor, the agency isn't required to disclose that, because under Section 506D1, it's not a governmental function, and it's not directly related to a governmental function. So the agency can just say, these aren't public records. I don't think you even need to get into the notice aspect of it. But again, if say it's the blueprints for the construction of a public school building, school districts build school buildings, and that seems to be directly related. So I think the blueprints would be subject to disclosure, but the names of who's working for the contractor, I think we have some final determinations on that point that's that information isn't it's not a public record. I don't even think if it's not a public record, I don't even think you need to go down to the next step of providing notice.
Could you please elaborate on the issue of personal email of elected officials, hopefully including some citations to relevant authority from the OOR or the courts on the issue? So the issue is personal email of elected officials.
Yes. I'm thinking, are they talking about like personal?
I'm thinking that when they use the phrase personal email, I'm thinking that they mean
email address.
Because Bagwell,
that they're not talking about when I email my wife to say I'm on my way home to get some milk.
Are you?
Right. I think that. Right. Yeah. So rather than using an agency email address, they use gmail.com or some other
trying to get around
service like that. And so a personal email address is the question.
Is it email address?
Or account.
A personal email account, right? A non-agency account, but they're using it to do agency business.
So, I mean, is the question is disclosure of the email address or the records on
the
records?
Email?
Okay. If it documents a transaction or activity of the agency, it's subject. It's a record. I think Silberstein dealt with emails. Is that the?
If Counsel? You go back to the example that I used with distinguishing between a record and not a record. I was at home in my family room on my personal computer on my own AOL account, and that example was intended. It doesn't matter how the record is sent or where the record was sent or what account was used or where it resides. It's the content of the record that distinguishes whether it should be public or not.
Yeah, and the Silberstein case, I believe it was either a supervisor or a commissioner was using his private email to communicate with the constituent. Right. And what the court looked at is that, even though they were talking about government business, the official had no ability to bind, the government agency. So what he was doing was he really wasn't conducting an activity of the agency. So that in that case, it wasn't subject to disclosure.
But that analysis didn't hinge on whether he was using Gmail or
Actually, he Right.
It didn't matter in that analysis.
It wasn't relevant.
And just as a matter of best practice, we always encourage, and this most often comes up with local agencies, but we always encourage agencies to have even their elected officials, school board members, borough council people, township supervisors, whoever, do agency business with agency email addresses whenever possible. It certainly makes responding to right-to-know law requests, possibly litigation issues as well, much easier. There are going to be some practical difficulties, right? If you're the arrow for a school district and you need to try and get access to records that might exist on somebody's Gmail account, but under the right-to-know law, they may very well still be records if they document a transaction or activity of the agency. If a request for information comes in but is not addressed to the right-to-know officer, and further, the right-to-know law itself is not mentioned in the request, but it is a request for information, is that something that the agency should consider to be a right-to-know request?
The Schneller case deals with that.
It's the Pennsylvania Gaming Control Board, right? Yes.
Gaming Control
Yeah.
Board. There, in that case, a request, which was clearly a request for records, was sent to the Gaming Control Board's press officer, and the press officer did nothing with it. And this was another case that went up to the Supreme Court. Supreme Court said, you've got to address this to the open records officer, something to give it some indicia that it's a right to know law request. So,
So in this case, the answer would probably be no. That's not an official right to know request.
as best practice, I mean, you certainly can, answer it, and it's always, I always counsel people to be as receptive to your constituents as possible because they're paying our salary.
Right.
Very true. A Commonwealth agency consistently steers right to know law requests toward its internal informal file review. That's in quotes, so I'm assuming that's what they call it. They indicate that their budget, staffing, and office space simply aren't sufficient to allow compliance within the deadlines that are in the right to know law, the 5 business days and 30 calendar days. Is it lawful for the agency to do that, particularly in light of the shall language that's found in Section 301A?
If it's addressed to the right to know officer, the clock starts ticking, and after 5 business days, it's deemed denied, and your appeal rights accrue. And the thing to keep in mind is that if you don't appeal within the 15 days, you lose your right to appeal. So it doesn't matter what they call it. If you've met your requirements, it's a valid right to know request, and the clock starts ticking.
Right. Once a valid right to know request is submitted, the agency has those deadlines, and at that point, the power to change it into something less formal is entirely in the hands of the requester.
Exactly.
The agency can certainly ask.
Right.
The requester can certainly agree or not agree. Either way, we have no stake in that at all. But it is up to the requester at that point.
Right.
Please. So let me try and repeat it just for the purpose that everybody here who might not have heard it on the webinar. The question is essentially, can a requester give to the agency a suggestion on here's how to search for what I'm looking for? I know enough about my request and your systems and whatnot to be able to provide this helpful advice to you. And then the question is, does the agency need to use that, or can they use it, that sort of thing?
I would interject here and say, yeah, I've had cases where requesters have made requests and provided search terms, and I think most agencies really appreciate it. It's also a point of sometimes the requester are, vague, we don't understand. It's always a good thing for the agency to have a dialogue with the requester and reach out to them and say, hey, we think you mean this, but could you provide some search terms, that we could use? So that has happened, yes.
Yeah, most agencies do respond to to search term queries. I don't think we've ever had a final determination that says you have to, and I'm not sure how that would play out.
Just got in a batch of new questions. It is now about 4:12, almost 4:15. So if you have any more questions for us, this is kind of last call for questions, because we're getting to the point where we've got plenty to take us through the end of the session. Here's the question. Should we consider including the cost of a paper copy of a record on our local agency right-to-know request form? Is that a good practice, George?
The form itself,
Right.
attaching a cost to that?
Oh, no, I think including what the cost of records would be, including some information about that on the form.
Yeah, that I'm okay with, yeah. I think
So it would be like 25 cents a page.
That'd be a good idea.
Yeah, that's good. It's always good to know what you're dealing with, right?
Exactly. Okay, we're going back to some timing questions here. We mentioned that the timeline might fall to the next business day when holidays are involved. If an office is closed for 5 consecutive days through the winter break, do they still go to the next business day, even though those are days that the office sort of chooses to be closed rather than being state or federal holidays or anything like that?
Like weather related, I wonder? I'm trying to...
I think if they're not open for business, they're not open
Right.
for business.
Commonwealth agencies frequently publish notice of an action or decision that allows 30 days for comment or response. Compliance with the right to know law allows agencies those 5 business days plus 30 days. Are we aware of any basis for requiring that a Commonwealth agency provide accelerated access when a legal deadline, such as a comment period, is pending?
I think under the right to know law, agencies have complete discretion to extend their deadline. That doesn't mean that there aren't other judicial avenues available. But strictly speaking, under the right to know law, they've got that complete discretion.
Back to timing, does the same hold true if the last day of the 30-day extension falls on a Saturday or Sunday rather than a holiday? So in either of those cases, if it falls on a Saturday or Sunday, the 30-day deadline actually becomes the following Monday.
Yeah, the way the statute works is that any legal deadline that falls on a Saturday, Sunday, or legal holiday automatically rolls over to the next day. So it doesn't matter which one of those it is.
All right. And final timing question. How is the 5 business day time frame calculated in the case of a small borough that has no borough building, no paid staff, and no regular business hours?
And all their records are kept in a shoebox in the secretary's bedroom.
Right.
From a policy perspective, it sounds like the borough should perhaps consider merging with a surrounding township.
Right.
But
I guess,
that's another issue.
Maybe they have an email address, and the open records officer gets it that way. That's the only thing I can think.
I don't think we've ever dealt with a case
No.
where
I
it's
haven't seen it.
that.
We're not saying it's never
small.
happened. It's just that it's always seemed to work itself out.
All right, and the last question we have right now, I think maybe the last question for the session, and I will thank again the PUC just real quickly for their facilities here. We really appreciate that, and thank everybody for attending. I hope it was useful. Should an agency allege that records are protected by the constitutional right to privacy? If that happens, wouldn't a requester lose an appeal if he or she cannot articulate the public interest in the disclosure of records? And I'm going to suggest that perhaps one of the things we tie in here is what I think you talked about a little bit, Charles, with the General Assembly's intent.
Right.
If an agency alleges that certain information is protected, but there's clear statutory authority, for example, that says it's public, that's one situation.
Well, I mean, let's assume that it's not expressly public.
Right.
Certainly an open records officer, can say this is protected by the constitutional right of privacy, and you haven't articulated an interest, so we're going to deny it. Then it would come to us, and we would go through the exact same analysis.
So it's like who does the balancing test, I think, is what
the
that was.
balancing test, yes.
Right.
Right, and if the balancing test exists, whether or not the requester articulates a reason. However, without articulating a reason, I think it's fair to say that at a minimum, the requester puts themselves at a significant disadvantage when that balancing test is
I think the balance at the beginning certainly tilts towards privacy, and it's up to the requester to make it tilt the other way.
Okay, and with that, Delene, do you have any final?
Thank you.
All right, everybody submit your CLE forms and all that good stuff. Thank you so much again for attending. If you have any questions that we didn't address, I think we got through them all this year, but we will be around here in person, and feel free to send any other questions to us online as well for those of you on the webinar, openrecords@pa.gov. We will post the PowerPoint presentation online soon, and hopefully, if we're able to, we will also make this entire presentation available as well. I know that PCN has aired it today and expects to air it again and to make it available on their website. So thank you to Pennsylvania Cable Network for that service as well. Thank you.